And
All right, welcome everybody today's webinar. I'm Steve Mahoney. I'm with the Greater Hartford chapter of SCORE. I'm with Kathleen Thompson, also from SCORE. And today we are fortunate to have David Dobin here, who is with Cohen & Wolfe. And David is going to be presenting today's topic, Legal Landmines, the Hidden Perils of Business Ownership. David, I will turn it over to you. Take it away.
thanks, Steve and Kathleen, and everybody else for joining us today. Thank you for listening. This is Legal Landmines, and we have a title of Hidden Perils of Business Ownership. Hopefully by the end of this webinar, some of those perils are not so hidden, and you can take some steps to prepare for the perils of business ownership. I'll tell you a little bit about me. My name is David Erez Dobin. I'm a partner at Cohen & Wolfe. I went to GW Law School, graduated from Maryland. I am a Knicks fan. I've got, that's a picture of me with my three tween/teenage kids. And that's a picture with my partners as well from my law firm, who are also very close friends of mine. I've been a business litigator for 15 years, involved in mediations, arbitrations, jury trials, court trials, appeals in all of the different forums for litigation. And the reason why I do this webinar, and I've done other webinars as well for other SCORE chapters, is I'm inspired by innovative and courageous entrepreneurs who put their own assets, their own lives, their personal lives, your own families, everything at risk to start a new business, to control your life, and to make the world a better place, and to make your own lives better. So I'm inspired by all of your bravery in going out and starting a new business, and I'm hopeful that some of the things that we talk about today can help you improve your business and be more successful. What we're going to talk about today, these are the main subjects that we're going to talk about. First, we're going to start with some important terms and concepts that I'm going to be discussing throughout the presentation. Then we'll talk about each of your legal relationships. That's where the perils are. Your legal relationships with your customers, with the government, with your property. All of those are what I call legal relationships, and it's those relationships that are the framework for thinking about how you can protect yourself from the perils, because those legal relationships are a predictor of what the future may hold in terms of any potential litigation. The importance of insurance in your business, the crucial role of written contracts, the importance of securing property ownership, separating business and personal finances, and making sure that you're protecting your business and your own liability, and understanding the regulatory environment. I'm a litigator. I've been, what that means is that when there is a business dispute, so if it's a customer who has a problem with the service that's been provided, or there's an entrepreneur or a business owner who isn't getting paid by a customer or has a complaint and it now needs to be addressed in court, or if there's two business partners and one of the business partners feels that they're being harmed by the other business partner, and there's a dispute among the business partners, that's where a client will come to me, and I will then conduct a diagnostic of the legal rights and obligations of all the parties to the legal relationships that are part of the dispute, and then provide advice as to what claims and what lawsuits might be available, and how to defend lawsuits as well, if necessary, in order to protect the business. And so what I'm going to do today is explain and identify some of the scenarios without getting into too much detail, because I cannot provide confidential information relating to matters that I've worked on, but I can provide general information about scenarios that I've seen that important lessons on how you can protect your business ahead of time can be gleaned from those examples in each of these topics. And I just want to say before we dive into the details of each of these topics, I am an attorney and I am providing general information. I'm not your attorney. So you're listening to this or me answering your questions here does not create an attorney-client relationship. I'm not providing legal advice to you. Any communications that you would have with your attorney would be privileged and confidential and not disclosed to any person. So I would also, if you are going to be putting questions into the chat or asking questions, please feel free to do so, but just be mindful of, if you do have an attorney, not to disclose your attorney-client communications and not to disclose any information that's confidential that may be harmful to you or to your business or relating to a legal dispute that you're currently in. That's something that we can, I'll provide my contact information at the end and you can reach out to me separately at the end. Two key outcomes that I want to achieve for all of you by the end of this webinar. The first is I want you all to gain some more understanding of your legal relationships and liability of your business and how to protect your assets. And the second is thinking about, for the first time, maybe not for the first time, but at least thinking about concrete steps that you can take right now to protect your business from legal threats, things that you can actually think about that would improve your chances of success in the event of a lawsuit, which is the most important aspect of liability when, especially when dealing with a litigator, someone like me who thinks about, well, what's going to happen when you go to court? How much is it going to cost for you to go to court? And what can you do ahead of time to make it cheaper for you later on if you need to go to court, which all ties into how to protect your business from legal threats. So there are three important terms that I'm going to be addressing throughout the webinar. The first is this concept of liability. What is it? It's the condition of being legally obligated to somebody, whether it's another person or to society or to government. And the key being enforceable by civil remedy or criminal punishment. So that means civil remedy or criminal punishment is a remedy is where a court enters a judgment, which is a final determination of all the rights and obligations of the parties in a case. And after one party gets a judgment, at that point, that party can then execute on that judgment, which means forcefully take money or property. So for example, if I represent a business owner and that business owner is owed money by a customer for purchase of equipment, and that customer doesn't pay. Well, the question of what strategy to pursue, how much, whether there is whether a particular litigation strategy is a good strategy depends on the ability to establish liability, the cost to obtain a judgment, and the practicality of obtaining an execution, meaning does that other person even have assets or money that it's worth trying to establish liability and obtain a judgment. And we'll be discussing steps along the way to make it cheaper or easier for your business to establish liability, obtain a judgment, and make sure that you can obtain an execution if you're owed money. And then it's vice versa for if the other way around, if somebody is claiming that you or your business owes money. So there are three phases of liability enforcement, and I'm only going to go into these briefly because really I want to get into the heart of examples of where that give us some lessons on how we can better protect our business from legal threats. So there are three phases. The first being the pre-lawsuit phase. Anytime there's some type of dispute. There's the pre-dispute phase, which is that's when everything's going well, right? You're a business and you're hiring employees maybe who are helping you, or you're signing up customers for your service, or you're invoicing, and you're performing the work that you've been contracted to perform, or someone's performing that work for you. That is the pre-dispute, pre-lawsuit phase. That's where we are at this stage in terms of me giving tips to each of you about horror stories or horror stories to show you the legal landmines, so that in the pre-lawsuit, pre-dispute phase, you can best prepare yourself for the inevitable, but hopefully, but usual, also avoidable dispute, lawsuit, and post-judgment phases. So throughout this webinar, I am also going to be asking each of you by yourself internally to have a piece of paper or a document open on your screen so that you can take what we're talking about and start thinking about how the principles that we're talking about in this webinar apply to your business. Legal disputes, so that includes debt collection and recovery. That could be something where you're being sued or somebody's being sued, you're being sued, or somebody is suing you. And when I say sue, I mean any dispute. I mean, someone's claiming that you owe money, or that you did something wrong, or the other way around, that you're claiming that somebody else did something wrong and you want them to do something. The first step is identify your business's legal relationships. So you have your own business. You may have, you as an individual may be the owner of a limited liability company or a corporation, or maybe you're a sole proprietor, which means it's just you doing your business. You have legal relationships with your customers, with the people who you work with, employees, investors, business partners, suppliers, vendors, all of these parties who are listed. So I want you to kind of take a few minutes. It doesn't have to be right now, but take a few minutes and identify what are those legal relationships that you have. So each of these legal relationships these are the parties who you will be at some point in a dispute with, potentially, and even if everything is going great today, and you want to be prepared now for the potential that you'll get into a dispute, and you want to make sure that ahead of time that you have protected yourself in each of these legal relationships. Okay, so think about these legal relationships, jot them down. I'll give you a minute now to kind of just think about that, and then we'll move on to the next slide. Okay, so the first bucket of kind of legal landmines that I want to talk about covers all types of potential legal disputes. So there have been a number of times where clients have come to me and said, I'm being sued, or someone says that I did the work improperly, and now they're suing me because they say that they need to fix the work that was done. For example, maybe it was a construction project for building fences, or putting an addition onto a house, or putting an addition onto working on the foundation of a large building. And oftentimes, small business owners will jump into the business without having proper insurance. So there's different types of insurance. There's liability insurance. There's E&O insurance. There's D&O insurance, which is directors and officers liability. That's if you are you're the member of a board. Maybe you're of a larger corporation. There's professional liability insurance. The importance of insurance is this. If you get into a legal dispute and you get sued, or your business gets sued, that's going to cost you money, whether you are correctly being sued or not correctly being sued. So, for example, I did have a client years ago who was sued by a former patient, and that patient filed a lawsuit, served the lawsuit on my client, and my client didn't do anything about it for about 6 or 7 months. They got it, but they were so busy with other things, with work, that they did not really focus on it or pay attention to it. So they came to me and said, I've got this lawsuit out there. I didn't do anything wrong. This isn't fair. And I need to deal with it because I wanted to get a loan, and a potential lender found this lawsuit online, and now I need to do something about it. And my first question always is, well, do you have insurance? Well, and have you made a claim on your insurance policy? And why is that? The reason why is because insurers have a duty to defend if there's a plausible chance that the judgment, whatever it is that the person suing is going to get, is covered by the insurance. Then the insurance company has a duty to defend. What does that mean? That means the insurance company pays for your lawyer, and you don't have to pay for it out of pocket. Unfortunately, there have been many times where I've had to, after I've spoken with the clients have filed a claim with their insurance company, and the insurance company says, no, it's too late. You were required to make a demand. You were supposed to tell us about this claim 6 months ago. Now it's 6 months later, and you don't have insurance. So you, business owner, have to pay for disputing this lawsuit. You have to pay your own lawyer, and if there's any damages against you and you lose, then you have to come out of pocket. That comes from the assets of the business, not from the insurance company. And I can tell you, lawyers are not cheap. So my rate is $425 an hour. That's actually on the lower end of many attorneys in the area dealing with business disputes. And if there's no insurance, that has to be paid out of the company's coffers. And there have been a number of times where even if the client is adamant that they did nothing wrong, it would be cheaper just to pay off the other side than to pay for a lawyer to fight the entire case and deal with and again, this goes back to the 3 phases of a lawsuit, right? There's the pre-lawsuit phase, the lawsuit phase, and the post-judgment phase. And so at each of those phases, once the dispute starts, there's a cost, and there's a cost in attorney's fees, and attorney's fees can be very expensive. So, and it could essentially bankrupt the business. One lawsuit could bankrupt a business if there's no insurance. So it's crucial that you make sure you have the proper insurance and talk to your insurance agent. So on self-reflection, I want each of you to think about, do you have insurance? for each of the legal relationships that you've identified in response to that first self-reflection that we had before, for each of those legal relationships, do you have that insurance? Is their insurance available for the type of claims that might be made against you relating to those legal relationships? And sometimes there's no insurance, so there may not be insurance always for certain claims. For example, if you're being sued because you stole money, there may not be insurance for that. There may be, but you should schedule a time to speak to an insurance agent, speak to whoever your current insurance broker is, make sure you have the proper insurance, because you may do nothing wrong, and the fact of not having insurance alone could put your entire business in jeopardy. So there was a question about what type of insurance you should have. I'm not an insurance agent. I'm an attorney who has experience dealing with clients who either had insurance and missed the deadlines to put their insurance companies on notice, or had or didn't have insurance, or had let insurance lapse. So, and my advice is the same to all of my clients, which is talk to your insurance broker, talk to an insurance agent. I'm pretty sure that SCORE also has volunteers who are specialists in different types of insurance. And I would schedule a time to speak with them to find out what insurance you need. And anytime so that's number one. And number two, if you ever are sued, or you think that you're going to be sued, or you're put on notice of a potential claim, the first thing you should do, even before talking to a lawyer, my suggestion is send it to your insurance company and make sure that you have insurance coverage. And there's also a question about a surety bond. That's a little bit different. I'm talking about insurance for claims. Surety bonds come up in different contexts. There are some contractual requirements sometimes where you enter a contract where you're required to post a bond for the work that you're performing. Again, that's something you should talk to your insurance agent about.
Just to let everyone know, we do have a video on our YouTube channel that says how to decide what insurance is right for your business. So you will get a link to our YouTube channel in the replay, and you can check that out if you want some information about that before contacting your insurance agent.
Thank you. That's great advice. The next topic I want to cover is written contracts. So there are so many, many of the cases that I deal with involve disputes where the contracts are not drafted or reviewed by attorneys beforehand, and so they're not really clear. They're a little bit ambiguous. They're ambiguous, or they are missing key important terms, or they're just no contracts at all, and contracts maybe had been prepared but never signed. And so on this page, what I've identified is this is the reason why you want to have written contracts. The written contracts should identify who are the actual parties, right? So I'm assuming that this is not an introduction to business entities or limitations on liability, limited liability companies or corporations, but as a general matter, individual humans like myself, I am not the same person. I'm not the same party as, for example, my law firm, Cohen & Wolf PC, right? So I have in my name, I have two different names. I have David Dobin and Cohen & Wolf PC. Cohen & Wolf PC is legally a separate person. So if Cohen & Wolf PC signs a contract, or if I sign a contract on behalf of Cohen & Wolf PC, that doesn't mean that I, David Dobin, and let's say I have a house in my own name, that does not mean that David Dobin, the individual, is a party to the contract. So a written contract identifies who are the actual parties to a contract. It's important that that written contracts, they say what the parties promise to do and when, how payments can be advanced or secured with liens, prejudgment remedies, which is the ability to attach assets before a lawsuit and a judgment is obtained, limits on what each party can do and achieve, what happens in the event of a dispute, and does the written contract contain all the terms? Can it be modified? So these are just some of the main points that you want to make sure your written contracts are including. And I'm going to give you here, I'm going to talk about a couple of examples of ambiguous contracts, situations where and the consequences of them. So I want everyone to take a look at the first bullet point here. Customers' failure, okay, to make more than 1/4 of the scheduled payments in a calendar year shall constitute a default of this agreement. Okay, so that's what this says. And let's say the customer makes 1/2 of the scheduled payments in that year. Okay, so in that calendar year, the customer makes half of the payments. The question is, and again, this is from the perspective of the business, right? From the perspective of the business, is this customer in default, right? And now you want to be able to, you as the business, you want to be able to sue the customer for not making any of the payments and to say that it's a default. So when you look at this, I want you to take we'll take 15 seconds or so to read the language in the contract. And I want you to think about, what do you see any issue with this language? So the issue with this language, and the issue that has come up that I've seen in cases, this comes from a particular matter that I was involved with, is the business takes the position, right, that by making 1/2 of the scheduled, only 1/2 of the scheduled payments, then they have failed. Okay, they have failed to make more than 1/4 of the scheduled payments. Okay, because they were supposed to make, right? They were supposed to, from the business's perspective, if the person only makes 1/2, then they have failed to make more than 1/4 because they have failed to make 1/2, right? So from the business's perspective, it's what this means is not made more than 1/4 because 1/2 were not paid. Therefore, there is a default because there was a failure of 1/2, which is more than 1/4. But the customer looks at this and says, well, hold on a second. Okay, I did make more than 1/4 of the payments. So I did not fail to make more than 1/4 of the payments. In fact, I made half. I made more than the minimum. This only required me to pick 1/4 of the scheduled payments in a calendar year. What does this mean? What this means, because there are two arguably reasonable interpretations of this provision of the contract, this is a recipe for protracted litigation that could last years. So we're talking about those three phases: the pre-lawsuit phase, the lawsuit phase, and the post-judgment phase. And this could drag out once a dispute arises and the customer says, well, I made more than 1/4, so therefore I'm not in default, and all I have to do is make 1/2. Then the business says, well, no, you did fail to make, you failed to pay more than 1/4. The cost of having to brief, file a complaint, an answer, depositions, reviewing contemporaneous communications, having a trial before a judge, either side can then appeal. We're talking about potentially years of litigations and tens of thousands of dollars in legal fees over a breach of contract. And if at the beginning of at the outset, when the contracts were being prepared, negotiated, and drafted, when in the pre-dispute phase, when everything's going well, if it was made clear that customer was required to make at least 1/4 of the scheduled payments, or was required to at least make 3/4 of the scheduled payments, then it would be clear and unambiguous, and it would not lead to very, very expensive litigation over who owes what. And so I've seen over and over again ambiguous contractual provisions that lead to years and years and years of litigation, and it's a significant drag on your business. So make sure that you want to be able to, when you're reviewing your form contract, your customer contract, that you're looking at it not only from your perspective of, well, we just want to get this signed up so we can get the money in the door, but also at some point, can my customer look at this provision of the contract and say, I don't have to pay, and why don't you come and sue me? Because that's how I do business, and that's the price of doing business. And so that's ambiguous contracts should be avoided in that pre-lawsuit, pre-dispute phase. There's also similarly, so before I go back to this, I also want to make one other point, which is when you have a business, and I know a lot of you are professional services companies. It looks like about half of you. There is a rule of contractual interpretation that says that an ambiguous contract is construed or interpreted against the drafter. And 9 times out of 10, the drafter is the business, right? The business sends the terms of service, prepares the form contract, and then sends it to the customer. And if that's the case, then in this circumstance, the customer will win, even after an appeal. And so you need to keep that in mind as well when you're reviewing your contracts.
David, we have a couple of questions related to that contract situation. The first is, what does the term default mean?
Mm-hmm. Right. So the term default means that it's another word for breach of contract. Okay. So in order to establish when one party brings a lawsuit against another party for any type of claim, each claim, whether it's a breach of contract or theft or any type of breach of fiduciary duty or negligence, every lawsuit that's made up of claims also consists for each claim what's called an element. That's a checklist that a plaintiff or a party has to prove in order to eventually get the court to enter a judgment, and then for the party who wins to get to execute on that judgment. For example, filing a judgment lien, or by attaching assets, or having a marshal forcibly take personal property and sell it to satisfy a judgment. each claim for a breach of contract has certain elements. And the first element is you have to prove that there is an agreement. The second element is breach of that agreement. And so default is a legal term for breach of the agreement. So a default in an agreement is a breach. And when one party, and oftentimes in the contract, I define what is a default. Sometimes a default will then mean that the party, the other party has the right to go ahead and sue at that point. Other times the contract will say there is a default, so there is a technical breach, but before the other party can sue, that party has to give the defaulting party an opportunity to cure, so an opportunity to fix it and notice that there is a default. And that's something that, as a general matter in terms of contract law, that oftentimes if the contract is silent about the ability of a party to cure a default, then oftentimes, if it's reasonable, the courts will say that another party has an opportunity to cure that default before a lawsuit is brought. So if you are the business owner, or you're the business and you're drafting your contracts and you want to give yourself as much flexibility in enforcing your contracts in the event of a breach or a default, you would want language in your contract that says, number one, this is what a default is, and it's clear, right? It's clear, for example, in this contract, right? In this contract, we can make this clearer by saying that if customer does not pay any scheduled payment, it shall constitute a default. And then the next sentence might say, without any further, that the defaulting party has no opportunity to fix it, has no right to obtain notice that there is a default before the business has before the business can take additional measures to enforce the contract. If you are a customer, or if you're a business and you're negotiating a contract with a larger business or another business, and you're the party that is performing, and there's maybe a higher chance that you might be defaulting in your contract, you would want to include a contract provision that says, if there is a default, the other side must give me notice in writing describing the default and give me an opportunity of 2 weeks, 30 days, 60 days to cure that default before the other side can bring a lawsuit. And if there is a cure, if there's actually the cure is, for example, after the business gives the customer notice that they missed a payment, then the customer has 30 days to cure that default. And the customer then does cure that default, then the business cannot prove the element of breach of contract, which is required in order to obtain a judgment and then to get a marshal to execute on that judgment.
Thanks. There's one more that's a statement, but there's almost an implicit question saying we won't deal with payment problems because full payment will be required before we work. So the implicit question underneath there is, are there other types of contract terms and defaults that could exist even with prepayment that aren't related to payment?
Right. So there are other, so yes, right. There are other contract terms. I think if I understand your question, what you're asking is, are there other types of defaults that are not payment related?
Yes.
And there are other types of defaults. So if you are, for example, you are a professional service, and you're a contractor, for example, and there are there are warranties, implied warranties for contractors who that you're warranting that the work that you're performing is workmanlike. It's in good, and it's in good, that what you're doing is not negligent, and that everything that when there's the warranty of merchantability, which means that it is that the products and the services that you're providing will actually meet what you say, the standard that you say it should meet. Meaning, if you're building a foundation, then you're warranting that the products you put in for the foundation are sufficient to hold up whatever structure is necessary. So even if the contractor, if the contractor performs and later it's found out that the work that was done was done improperly, and maybe there wasn't enough fill used, or it was the improper materials, that could be a breach as well. And in that circumstance, the owner or the homeowner would provide the contractor with an opportunity to fix that at the contractor's own expense. That's the cure. But that can be a default. Now, requiring payment up front is one of those tips that I kind of put here in this list above, talking about, how can payments be advanced or secured, right? Getting a retainer payment, or having payments made up front. That does not, so that would give you the ability as a business to have that money in hand, right? That does not necessarily prevent a customer from claiming that you didn't perform, right? And then they would have to sue you, but it would 100% put you in a better position because you would already have that money, right? So that is a provision that if you're able to get it and it is legally enforceable to do that, then it makes sense to do that. One example that kind of sticks out to me that you cannot do that, for example, is in a residential lease. So a landlord cannot get an entire year's worth of rent up front before the party moves in. There's a statutory prohibition that says that you can only get a certain amount in terms of a security deposit equal to 2 months' rent, and you can't get more than that. And so that's one example of where payment up front is something that you may be able to get, but it wouldn't be necessarily legal. It wouldn't be legal, and you as a business could be exposing yourself to additional liability, including attorney's fees and punitive damages under the Connecticut Unfair Trade Practices Act for doing something that the statutes don't allow. And that relates more to one of the buckets that we're going to talk about in a couple minutes, if we don't run out of time, relating to the regulatory environment that governs your business. With respect to so we talked about having a contract and making sure that it's clear. The same risks apply when you have no written contract. If there's no written contract, then it's a he said, she said, they said type of scenario where it infinitely increases the cost of litigation, because now when there's a written, clear contract that contains all of the terms, as the lawyer, I can take that written contract, submit it to the court, and there's law that says because it's clear and because it contains all the terms, we don't need to have we don't have to have a hearing, we don't have to have a trial, we don't have to have discovery. All you need to do is look at the contract, and you can identify who's at fault. If there's no written contract, meaning even if you've drafted a contract, but it's not signed, and there have been many times where I've dealt with clients who don't have contracts that are signed by both parties. If they're not signed, then it's as if there's no written contract. And then it becomes that much more expensive to litigate because you have to have a hearing. You have to have witnesses come and testify. The lawyers have to prepare the witnesses to testify. The lawyers have to review all the correspondence between the parties to the lawsuit, prepare for a hearing, prepare for a trial, provide the law to the judge, and then because it's such an amorphous and fact-based and specific to each situation, it's really hard to tell whether the business is going to win or the business is going to lose. And it gives many parties an opportunity to appeal. So having no written contract also is just as bad as having, or worse than having a contract that is ambiguous. And so I can just tell you, I've been involved in a case since a federal lawsuit since 2000 that was brought in 2013 relating to a business relationship from 2009 and 2010 that is still pending to this day in the federal appeals court, precisely because the parties did not have a written contract. Instead, they had one party said that the other party agreed to something, and the other party said, no, I didn't. And so instead of having one contract that says, all right, these are the parties, this is what they agreed to, instead, we have to go to court, put on evidence, obtain the evidence, get subpoenas from other parties, review documents, which is an impossible situation for businesses to be in. So for your purposes, in terms of self-reflection, think again back to your legal relationships. Which of your legal relationships are governed by written contracts and are not? When was the last time an attorney reviewed your written contracts? And it's not on here, but what process, especially if you are not the only person and you're just an owner and maybe you have others who work with you who are negotiating those contracts for you, what processes do you have in place to make sure that every contract you have signed with your customers is actually fully executed and communicated to all the parties, and that the proper form, the latest, greatest, most updated form, is the contract that's being used? And then think about which of your relationships are governed by verbal or handshake agreements. Whatever's in your text messages, your emails, or in your recollections, those are the terms of your contracts. Think how it might be improved by having a written contract. The next phase is that I wanted to talk about, where there are perils to your company, are securing your business property. So that involves intellectual property, personal property, and real property. With respect to intellectual property, that means copyrights, is trademarks, and patent. Usually, the two that I see most often in my practice are copyright disputes and trademark disputes. You can register. So one thing that people don't always realize is, even if the copyright is not registered or a trademark is not registered, that does not mean that the person who uses that mark or who published that material, which is copyrighted. So copyright covers something, original works of authorship. Trademark is protection for a packaging or slogans or a trade dress, a mark that's used by a company in business. Even if it's not registered, whether it's registered, you can register with the state or with the federal government. Even if it's not registered, it's still entitled to protection. The important fact for purposes of ownership of intellectual property is when it was first used. So I could use Cohen and Wolf in my business, and maybe I've never registered it, as a trademark, for example. But let's say I used it starting, 100 years ago. I've been using it, and anyone who goes online can see that I've been using Cohen and Wolf as a trademark. I still have rights to use it, and no one else can use it. So what does that mean for your business? It means that when you're starting off, or you're starting with a new business, or you're starting with a new product, you want to not just you want to hire an attorney to do a intellectual property search. And it would involve searching state and federal trademark databases and copyright databases. But it should also be looking for what's called common law rights. And that's non-registered rights in particular trademark or copyright. So that's Google searches. That's the use of a website. And so while you may hear from others that what you should be doing is go ahead and trademark your logo or register your copyright in whatever works of authorship that you have. And there are benefits to that, the most important of which is there's a presumed validity. So it's easier to prove in court that it's a valid registration or valid mark or valid copyright. But not only that, but before you actually start using anything, make sure you've done enough research to know that the name you're using, the logo that you're using is original to you, and it's not something that someone else has used before. And so I'll give one example is it's actually from my my sister who started a company, and she had a great name, and she invested, it was a small business. She was doing education consulting, and she just kind of jumped right into it, started using a name, and started publishing on Facebook, bought a domain, and within maybe a month of her starting to market her business, she got a cease and desist letter from an attorney for some company in a different state, but also in doing something different, but also in the education space, saying your mark is confusingly similar to our mark. And luckily for her, it was early on, so she was able to reverse course and change her name after having done the research to figure out what name would not be infringing, and now she doesn't have that problem anymore. So for your purposes, I'd like you each to reflect on one piece of intellectual property that your business owns, whether it's a logo, a product design, a website, and note the steps you've taken to protect it. So that would be, have you done a search to see if anyone else is using that name or something confusingly similar in the same industry as you? Have you done a search to see if you may be infringing on anyone else's marks? If so, then you should talk to a lawyer about how you should address that situation. That could mean one could be reaching out to the party and demanding that they stop using it, or getting a trademark registration and putting the other party on notice, because then you can kind of create a situation where the other party waives any right to challenge your registration. And so that's something I want you all to think about as after this meeting. I don't know. I did see that there were some additional questions that were added.
So David, we can keep, how many more topics did you have? Because I want to make sure we cover all your content before we address any more questions.
Yeah, so the last, I was just going to cover, two more topics, and I can just run through them in the next, 5 minutes, just to kind of and then we can jump into Q&A. Does that work?
That sounds great.
Okay. So one of the topics and the kind of perils that I've come across in my business is I represent business owners who are maybe minority shareholders or minority members of a company, or partners with others. And there, at some point, there becomes a dispute. And it's important to understand that, as I explained before, that a business entity like a limited liability company or a corporation is a separate person under the law. So if I give money, and the reason why statutes and the law gives this protection to separate persons is to encourage economic growth and investment. So if I want to donate, or if I want to invest money into Google, and I invest $20,000 into Google, then I want to make sure that if Google gets sued by somebody who says that they were wronged by Google, that the only thing that I can lose is the amount of money that I invested in that business, in Google. The same applies to your business. If you have personal assets, and then you want to start up a business and you invest money into that business, you don't want your other assets, such as maybe you have a house, maybe you have a car, maybe you have a retirement account, bank accounts, investment accounts. Those are all in your name, in your name. They are not in the name of the LLC, or the corporation. So when the business gets sued, it's the corporation or the limited liability company that is named as a defendant. And remember the phases. There's a lawsuit phase, there's the judgment, and then there's the post-judgment phase. The post-judgment execution, the taking of the money to satisfy a debt, can only be done against the parties to the lawsuit. So if a business owner is separating their business and personal finances, the law will then recognize that they are in fact two separate people. And so assets of the company will be available to satisfy a debt owed by the company, but assets of the individual will not be available to satisfy the debts of the business. So if your business ends up becoming a defendant in a lawsuit, and the business, for example, there's a judgment against your business for $200,000, but the assets of the business are only $100,000, the other side cannot go to your assets and say, I want that $100,000 gap from your business, from your assets, from your house, from your bank account. Why? Because you as an individual were not a party to that lawsuit. The big exception that we see all the time is a concept of piercing the corporate veil. And the biggest kind of factor that will allow a court to use the personal assets to satisfy the debts of the separate company are whether the owner of the business was using this business's bank accounts and finances as their own. And if they were, then a court is more likely to disregard the separate person status, and the business owner is then putting his or her own individual assets and putting those at risk. And that's why I warn all of you to separate your business and personal finances, list your business expenses, see if any have been paid from your personal account, talk to your accountant to figure out a way to remedy that. And imagine one day somebody going through your business's bank accounts and your business's QuickBook records or accounting records and looking at every single expense and saying and identifying, is this for business purposes or is this for personal purposes? If it's for personal purposes, then you should that should not be part of your, that shouldn't be part of your business finances. You should have a separate bank account. You should have separate books for that. Finally, understanding the regulatory environment. That involves consumer protection statutes that apply to every business. The most important one that I see in my practice is what's called the Connecticut Home Improvement Act. The Connecticut Home Improvement Act makes certain contracts unenforceable unless they're in writing and they contain certain required statutory provisions. And there are many, many times when we have clients who come to us and say, we did work for this house, we put in, we did tens of thousands of dollars of work. I ask, where's your contract? And the response is, here's the contract. It's one page. It doesn't have the license number. It doesn't of the contractor. It doesn't have the starting and end date. The Home Improvement Act also requires that no work be performed by the contractor for the home owner, except after 72 hours, because there is a statutory right of a homeowner to cancel within those 72 hours. So, and if the contract does not comply, then the contractor cannot get paid for the work that they've done. And I've seen it over and over and over again. And even worse, if the contractor then goes forward and sues on that unenforceable contract, that in and of itself exposes the contractor, him or herself, to damages for violating the statutes. So that's the most telling example is the Home Improvement Act. And you'd be surprised what constitutes a home improvement. I've had a judge who has ruled, I've seen in a case, that interior decorators are home improvement contractors. And you wouldn't think so. I've also seen judges who say landscapers, if you're just mowing the lawn, that's a home improvement contract. That means it has to be in writing and it has to have all of the required contractual provisions. Otherwise, an owner can say, forget it, I'm not paying, and there's nothing the contractor can do. The second and third parts I just want to quickly highlight is if you are operating a business out of your home or wherever it is that you're locating, review your zoning, the zoning laws that apply. Are you allowed to do that? If not, then zoning enforcement officers in each town have the power to issue fines of up to hundreds of dollars a day. And I've been involved in cases defending owners and defending property owners from those zoning fines and enforcing. And the towns will get a lien on the property, and then can which quickly escalate and give the towns the ability to take your property away. Finally, if you are working with independent contractors or employees, there are strict rules about overtime, about minimum wage, and that you need to be complying with respect to these, with respect to whoever you're working with. It's a very gray area of the law, so you should be communicating with an attorney about that. But I think the main issue there is, do you control the schedule of the person who is working for you? If so, they're more likely an employee. And if it's a big enough company, and the Connecticut government, the state of Connecticut Department of Consumer Protection, Department of Labor, get wind that of that situation, that employees are not being treated as employees, then they will launch an investigation, which will lead to, again, legal fees, significant legal fees and expenses in defending that investigation and responding to that investigation, and then civil and potentially criminal penalties at the end of the day. And I've seen that. I had a client where we were doing a project in Bridgeport and after the project was finally done and we were all ready, the entire thing was done, they got a notice from the Department of Labor saying they're conducting an investigation, and the project for which we were hired became an entirely new project, which was defending a Department of Labor investigation. And so just beware of that as well.
David, that's a good it's a good segue. We've got a webinar coming up on June 4th where we've got an attorney who's going to be specifically talking about employees versus 1099 contractors and going deep on that topic. So for folks interested in that one, if you think that's an issue for your business or you just want to learn more about it, highly recommend you sign up for that. You ready to jump in and do a few questions here before we wrap up?
Sure.
All right, great. Thank you for doing this today. This was wonderful. We'll try to do a handful here before we wrap up in a few minutes. First question, how liable are employees for carrying out the duties of their position as directed by an owner or officer when those duties are in violation of ethics or possibly illegal, for example, withholding tips in a restaurant?
Right. So I in terms of, you mean for withholding tips in a restaurant?
As an example.
As an example. So if you are, for example, if you're a manager of a restaurant and the owner is telling you that you need to be that you need to be doing this, so I will say this, for intentional statutory torts, you can be personally liable for that. You can't rely on being told to do something wrong. And that's not a defense to the claim against for example, for the individual, right? So I'm not speaking specifically about your situation. Every situation is different. But as a general matter, each individual person is responsible for the conduct that they undertake with respect to another person. So in a scenario such as that, let's talk about the legal relationships. There's a legal relationship between you as the middle person to your boss, right? And you may be able to sue your boss for whatever liability you have to the individual who you are harming. But with respect to the legal relationship, the courts will take the legal relationships as they come. So there's two legal relationships. There's the relationship between you and your boss, and the relationship between you and the company that is employing you, if you are the middle person. And then there's a relationship between you and maybe the subordinate who you are withholding tips from. And the court will look at that relationship between the person who's harmed and the individual who's kind of carrying out the duties and say, between the two of you, at least between the two of you, who's the one that's responsible? And the one that's responsible, the fact that somebody told you to do something isn't a defense to a lawsuit that might be brought against you by the ultimate person who's harmed, but you may have remedies against the person who told you to do that. But that's two separate legal relationships, and you would want the court to decide both of them. But at least that's not a defense necessarily. I mean, every case is different, but that's not necessarily a defense to a claim that might be brought against you individually by the person who's ultimately harmed. That person who is ultimately harmed has a legal relationship with you and has a legal relationship with your boss / the business. And it may be that at the end of the day, after all the claims are asserted and all the judgments, that you are not or the middle person ultimately doesn't have to come out of pocket because the owner or the business will. But as between that, the person who's carrying out the orders and the person who's harmed, the person who's carrying out the orders does not have a defense based only on the fact that they were carrying out orders. It's kind of like it's a less extreme and obviously version of kind of the Nuremberg
Yeah,
defense.
just because you're following orders doesn't mean you're okay. Right. Okay, that's good. We're gonna we'll take a few more questions here. I did want to ask folks if they have a minute to answer a quick poll. This is if you are interested in a score mentor. If you are, just answer. You can answer yes to the second question. And if you do, you'll get an email from me telling you how to sign up for a score mentor. If you don't, that's fine as well. That's the only email you receive from me. We won't badger you with emails. But while we're doing that, just a few more questions here before we wrap up. Is there a way, we got a question about, can you safeguard your business against any future divorce with your spouse? Is there any insurance to protect against a divorce or any specific company type or structure that can help your business from being sold off in case of a divorce?
Right. So I'm not aware of any insurance. I mean, that's something that you would want to talk to an insurance company about. I will say that so if you're going through a divorce, I'm not a divorce attorney, but a lot of the work I do is actually tangential to divorce. So I will represent clients who are involved in divorce and who own businesses. And the property of a spouse, which would include a wholly owned LLC, ownership of a company, ownership of shares, that is considered marital property in Connecticut, and it's subject to equitable distribution. So what you can do to protect that is what I would say is it's so I've been on I've seen people do things to move assets out of their name and into the names of other family members, for example, or but the downside of that is that in a divorce, in a contested divorce, those family members may end up just being caught in the middle because they are holding on to, and the allegation would be that they're holding on to property that should be and is part of the marital estate, and it could end up, it ends up being more expensive for the person who's trying to keep assets out of the marital estate. The other potential way to address this issue is what's called a prenup, right? It doesn't have to be a prenup. You can actually have a postnup, which is an agreement that's entered into after marriage that covers the type of issue that you're talking about. But as a general matter, if you own it and you're married, then your spouse has an interest in it. And so there are things that other than there are illegal things or attempts to hide assets, all of which will only in my opinion, harm you in the long run, harm individuals who try to do that in the long run, because courts see through that. It's something they see every day. And at the same time, it could just rope in family members into a contested lawsuit and force them to incur additional attorney's fees and potentially expose them to damages for what's called fraudulent transfer of assets. But the recommended course would be to try to reach an agreement with the spouse. And maybe it's it's too late for that. Oftentimes it's too late for that, or it's too difficult for people to actually, and they won't agree to it. And that's the nature of the divorce, the family law in Connecticut.
Okay.
I hope that helps.
All right, that's good. We do have a few questions in here about insurance. I just want to remind folks, David's not an insurance expert. So if you got a question about insurance, recommend you contact an insurance agent and talk through with them your business situation and what you might need help with. We did get a question here. I'm not sure if you know much about this, but what are the status of non-competes? these days. I know there's been some recent developments on this. Do you know what the latest on this one is for business owners?
Right. So I do know, as a matter of, general matter, non-competes have to be reasonable. So they have to be reasonable in scope. They have to be reasonable in time. Evidence that a person who's signed a non-compete is in fact, knows and knowingly enters into that. I know that there have been some recent federal rules that have come out on non-competes, but before any of that, before entering into a non-compete or non-solicitation agreement, my recommendation is, and I would always talk to my partner, Stuart Katz, who's a labor and employment lawyer, one of the best in the state, who's at my firm, and who deals with these on a regular basis. And, so I would, because it's ever changing, I would schedule some type of consultation with a labor and employment attorney to discuss the specific context and whether it's enforceable.
Okay, good. We got a question here from Charles. You mentioned about resources other than Google to determine if a logo or name trademark has already existed. Do you have a recommendation where people can look?
Right. So there are state and federal. So there's the federal trademark database. There are also copyright. There's a federal copyright database, and there's also Connecticut trademark databases and registrations. I would also look, especially if you're in Connecticut, I would look to see if the name that you use, for example, for your business, you want to do a search of other business names, right? So with the Secretary of State website, you can look up names. The reason I suggest Google is to go beyond just what's in the registered databases. And another, and this is again off the top of my head, other things that you may want to look at. For example, you might want to look at, there are websites like where you can look up domains that are owned and maybe might not be captured in a Google search, which can, come up with 10 million results, but you can look up domains and see if there are other people who own certain domains that are confusingly similar. So I had a case where my client sold, I won't get into the details, but sold similar products as another company, and he bought a domain, and that domain added the word S to make the domain plural, and instead of which was one letter off, so it was obviously different, and so somebody would go to that instead. And he had never done a search to see if there was a non-plural version of that domain. And there is a federal statute that prohibits squatting, or spoofing other domains, and which is similar to trademarks. And he ended up having to, give up that domain because it was confusingly similar to another domain.
All right, great. So we got a couple more questions here, and then we'll wrap up. Before this question comes from someone who says, before I meet with anyone regarding my business idea, what should I do to protect my intellectual property?
So that's a good question. And I think we talked a little bit already about, the informal searches that you can do. If you reach out to so I'll say this, that the Connecticut Bar Association has a great resource you can look up attorneys by practice area. There are also other attorneys at my firm they're not dealing with litigation, right? They're pre-litigation, pre-dispute lawyers who will help you with all of, addressing your contracts and your intellectual property issues before the perils, so to speak, that we discussed in terms of the disputes that I've been involved with and talked about today. What you can do is you would speak with an intellectual property attorney and that attorney could then put you in touch with a search service. So, and that search service they'll give you, my understanding is that, so what some of my colleagues will recommend is about a $500 or $600 charge to have a company go out and conduct this search for you to see, they'll check the trademarks, they'll check copyrights, they'll check the websites, and and entity names for different states, and tell you if there's anything that your specific logo or your specific whatever other intellectual property you have, that whether it's already in use or not, which would then give you the opportunity to change it before you start your business. And then the next step would be, assuming that that what you have, your logo, is original, it's yours, then the recommendation would be to get it trademarked. And go to the trademark office, file a registration with trademarks as well. And then and that's important. And I also want to point out something else, which many people don't know, which is if you are using a name for your business, a trade name, right? So let's say I'm David Dobin and I am doing business as, but I do advertisements, and my advertisements all say Dobin Law, okay? If I start calling myself Dobin Law, my business Dobin Law, that is not a separate person, okay? That is just a name that I use. It's called a trade name, and it's you may hear of a DBA, or doing business as. And if a person, whether that's a company or an individual, is doing business as a different name, so if I'm doing business as Dobin Law, but Dobin Law is not a separate corporation or limited liability company that I've formed with the Secretary of State, then in the town where, under Connecticut law, in the town where I am conducting my business, I actually need to register with the town, the municipality where I'm doing the work. I have to register my trade name. And so that doesn't create separate liability, limited liability, but what it does do is, if I don't do that and I use a trade name, then I am committing an unfair trade practice, because I am tricking people into saying that I'm Dobin Law, when in fact there is no Dobin Law. I'm actually just David Dobin, and Dobin Law is not a separate person. And if I have a contract and I sign it as Dobin Law, nobody would be able to sue me, because they wouldn't be able to figure out who I am. They would just sue Dobin Law, but Dobin Law isn't a person that exists. So
okay. That's helpful. That's helpful. We're going to do two more here, and then we'll wrap up. We got one about, do you need a zoning certificate or a written approval document to start working from your home office? Do you know the answer to this one?
So I don't, I mean, I think it depends on the
type of work
that you're doing, and it also depends on the town that you're in. But that's something that, we can get yeah, I mean, that would depend on something, again, like with almost all legal questions, everything depends on the circumstance. So if for example, if your work from home involves a massage parlor or something where people are coming to you, that may be something that's barred by zoning. On the other hand, if you're just working from home, you're doing, you're an independent contractor, and you're just, let's say you're just you're a copywriter, right? Or you're a designer, a web designer, and you're working from home, then my gut tells me that you don't need to check with zoning. You don't need that. There's no zoning prohibition on that, because there's no external impact. But I think that you need to conduct a little bit more research on that.
Okay, good. Last question was probably one that's on a lot of people's minds, is what advice would you give business owners when they're looking for an attorney? What kind of questions would they ask? What kind of services? what would be your advice on maybe a couple things that they should look for?
All right. So the first step would be assuming we're talking about someone who's just starting out, work on your business plan first. Get your business plan in order, work with the SCORE volunteers to have your business plan, include in that a budget for an attorney. And you'll want to have an attorney, a business law attorney. And again, for me, I'm a business litigator, but a business law attorney or others that I've done as well for small businesses could involve the intellectual property discussions that we have talked about and that we're asked about, the searches, reviewing customer contracts, and reviewing practices for enforcement of contracts. So one part of my practice is, while I do litigation, is because a large part of my practice is also collection and business debt collection. One of the services I perform for my clients is I will review their customer contracts and then conduct trainings with the owners or employees of the company on the forms to be used and the processes to be followed in order to ensure a complete enforceable contract that can then later be enforced. And so you would want to ask, you'd want to talk to an attorney, a business law attorney who would review intellectual property issues who can also help you with preparing the documentation you need in order to form your business, such as a limited liability company, and contracts with customers. If you have a partner or other people with whom you are entering into business, then the person with whom you speak that attorney can also prepare an operating agreement or a shareholder agreement that can be used when you're signing up, whether new investors or new partners.
All right, that's great. David Dobin, thank you very much for teaching this today. A lot of great information from folks. Here's David's contact information. You can see it. I want to thank everybody for joining today. Sorry we went over, but there was a lot of great interest and a lot of great questions, and I'm sorry we didn't get to everybody's. Again, if you're looking for more information on SCORE, you can go to score.org, where you can sign up for a mentor. You can also check out our webinars on our YouTube channel. Search for Greater Hartford SCORE on YouTube. And while you're there, you can sign up to be notified, subscribe to the channel, and you'll be notified whenever we add a new video. Thanks, everybody, for joining today. Hope you enjoy the rest of your day. Take care.
Thank you.